Hello, welcome to the HR Examiner podcast, where we have deeper conversations with all of the interesting people in HR and HR technology. Today, we're going to be talking with Heather Bushing, who is, as you know, a partner in the HR Examiner, and we're going to talk about the latest changes in the world caused by California regulations regarding AI and employment. So with that, Heather, what's going on?
Yeah, well, I guess the biggest news is that Governor Newsom vetoed the No More Robo-Bosses Act, which would require that humans be in the loop for termination and disciplinary hearings or decisions, that you could not use AI solely to determine who would be terminated. And he felt that the burdens involved in the law were significant. I don't see it. It was mostly notices that you could have put on in an email or on the employee portal. But anyway, back to the drawing board on that. But California did pass a broader AI regulation that has to do with frontier AI development. And that means that the really, really big firms, and I think the definition of frontier development is 500 million in gross revenue and a model using 10 to the second flops. and that's how much is being
How much flopping it does.
How much flopping it does. Yeah, it's it stands for floating point operations per second, and it's analogous to instructions per second, but it gives a more precise measurement of how the computer is functioning. So, this is something that is only going to apply to very few organizations, but it gives a signal for what the regulators are looking at, and they're looking at harm. They're looking at the potential for harm, and they don't know exactly what to look for because the technology is moving fast and law moves slow, and the people making the laws are only partially informed and understand what's going on and what's at stake.
Huh. So let me make sure I get this. A frontier company is a big, monstrous company. You'd be tempted to say that that's exactly what a frontier company isn't. So
Right,
help me a little bit.
Exactly. Well, I mean, they're looking at OpenAI would be an example of someone who might qualify. So they're looking at people with a lot of data, a lot of funding, who are currently in business and making money at it, because those are the people who have the incentive to keep developing, and they're trying to determine where the risks might be. So the obligation under that law is to determine risk. They're imposing the obligations on the AI companies to determine the risk of what they're doing. And a catastrophic risk is defined as the death or severe bodily harm to 50 or more people, which just seems kind of crazy to me, but that's the standard. And up to or over $1 billion in economic damage. So that is considered catastrophic risk. So these companies are required to assess whether their use cases could cause a catastrophic risk. and to disclose their model and their ways of assessing it, and to some extent the results.
So I want to engage your brain with the question that I know you're not prepared for, you probably haven't thought about very hard, but it's raised by this stuff. Of course, it's your favorite. The number of people who commit suicide statistically is 18 per 100,000, or 1 in 7,000 people commit suicide in a year. Now, that's the normal level, right? And so if you've got 1 million users, you're going to see 180 suicides in the user base. If they're users and they commit suicide, how do you tell where the fault lies in something like that?
Yeah, it's a causation analysis, but I don't think it's very clear how you do that. And the regulators are leaving it to the developing companies to figure that out, but they have to disclose what their standards are and how they're assessing and evaluating.
Yes, it's an interesting thing, because if you did everything right and you had 1 million users, 180 of them would kill themselves, and so there has to be some limit for sort of the background data to be a baseline.
Sure. And you could do that with statistical analysis to understand, what the delta is between people who don't use this and people who do, I guess. But I'm not sophisticated enough to understand it.
Well, it gets developers into a pretty weird place, right? Because newspaper headlines rarely have to do with trends. You don't see a headline about the number of car accidents is going up or down. You see a news article about this spectacular crash that happened on Highway 1 at 2:00 this afternoon in Santa Barbara. Right. So anecdotes are the fuel of the media. And that means anytime somebody kills themselves, it's held out as an example of what's wrong. And I have been trying to puzzle through how you navigate that. I just don't come up with good answers.
It's difficult. It's expensive. The truth is becoming more and more burdensome and expensive. And regulators don't know or understand. And so they are trying to get the companies who have a complete disincentive to explain that and figure it out, or even mitigate it necessarily, to do the work for them. And what could possibly go wrong?
What could possibly go wrong? Okay, so what else is happening in the employment law world?
Well, the Biden administration had issued an executive order ordering federal agencies to assess risks of using AI. And of course, that executive order was one of all of the prior executive orders that was rescinded at the beginning of the current administration. So federal agencies have backed off of pretty much all things AI, which means that the burden is falling to states, and California, as usual, is taking the lead, with some limited success. They issued new regulations this year on using AI in employment decisions, but mostly all. So let me back up 1 second. Regulations cannot make law. just like executive orders cannot make new law. Regulations are interpretation of existing law. So they can explain it, they can refine it through additional consistent requirements, but they can't actually change the law. So what they did is say you cannot use AI in employment decisions that result in discrimination. And that works because I've been saying that from the beginning. Discrimination is illegal. It doesn't really matter how you do it. And that is and that is true, whether you are discriminating against an individual based on a protective factor or whether you are enacting policies or processes that have a discriminatory impact on particular groups of people because of a protected factor. So that's not really news, but they are requiring that employers keep records for 4 years, which is probably a good idea. They may require risk assessments for employers to determine whether their use of AI is causing discrimination. And I think that is a fabulous idea, regardless of whether it's required. We need to understand what these tools are doing in our outcomes. And so we should be doing risk assessment and be doing compliance audits for demographics to determine whether there is bias or a disparate impact in our decisions, and pay equity analysis to understand where there are continuing pay gaps, where we're developing them, and that can tell us more about our systems and our organizations as a whole and what's going on. So I think one of the keys is to audit your outcomes and go in and figure it out and mitigate it. And one of the nice things about the new California regulations is that it expressly says that regular audits and work towards mitigation is a defense to liability.
Awesome. So I'm going to drag this off to the side, and I have a couple of questions for you. The first one is longish, and that is, I am a serious believer in the idea that if you don't get pay right, all sorts of ills come out of not getting pay right. And getting pay right means it's internally equitable, it's externally competitive, and it's transparently communicated.
I'm very familiar with that definition.
Yeah, I know you are. Now, all of the things that you described are ways of telling whether or not your compensation system is working properly. And pay equity analysis is sort of the top level, but being able to see bias in your organization based on decision making tells you some things. Because compensation is the foundation of work, meaning people don't show up if you don't pay them.
Unless you're the federal government.
And even then.
And even then, you have to pay them eventually.
Yes. The stuff that you can do once you get pay right makes organizations significantly more flexible and more adaptive. You can't really get to engagement or higher levels of productivity until you solve the basic compensation problem. And so I think it's interesting that there is a increased emphasis on discovering bias inside of systems regarding the people in the system. That's pretty exciting news.
It is, because we have the technology. I mean, we have the data and technology, and it's all coming together, and the tools are being developed in ways that are affordable, effective, and easy to use. How cool is that? But we have to actually use them.
So a California law about the use of AI, does that apply to California citizens? How do you tell which companies have to comply with that law?
Generally, you look at who is being protected. And so in these cases, it's applicants and employees. And so it's all applicants and employees who are California residents. And you know who your California employees are, but you don't ever really know who your California applicants might be. And so that's why everybody watches what California is doing, because as we've talked about a million times, little packets of information don't come with passports or license tags, saying. So if you're recruiting, especially for remote positions, but recruiting for any position in California, um, you it potentially includes everyone.
Okay, so is there any way that you're aware of that I can tell if my system is being touched by somebody from California and I therefore have to comply, or do I just have to comply because there's risk there?
You look for the avocado.
You,
I'm being silly. No, there's no way to tell.
there's no way to tell, but there is a way to tell if it's an avocado.
Well, assuming you can define an avocado.
Okay,
Yes.
so I think what you're saying is that while DE&I has suffered some damage, that what's actually happening in the law and in the places where regulations are still enforced is that there's an increasing emphasis on understanding bias and discrimination in organizations. Is that fair?
Absolutely. Absolutely. Because these laws protect everyone.
Right.
They
Right.
protect everyone.
So what else are you seeing in your broad view of employment law and regulations? What's going on?
Well, some other states are doing some interesting stuff. Let's see. New Jersey just issued some new regulations that also prohibits AI discrimination. So that's sort of the, look, if you're using this stuff, make sure it's not discriminating. Illinois is doing a series of notice and consent requirements, which is a consumer law based approach. All the warnings that you get when you buy a toaster, or but the problem with that approach is that it assumes that the person involved has a choice, and in employment the person involved rarely has a choice, even if they technically can choose not to apply to this employer that has AI biometric testing analysis of your, I don't know, whatever. But it's a common approach, and we've seen it in some of the proposed legislation in multiple states. But Illinois requires notice and consent before AI can analyze a video interview. You cannot use AI to analyze information like zip codes or inclusion in a protected class for employment decisions. And it's easy to make a rule like that, but how do you actually implement it? Because AI doesn't really segregate that information, nor can you when it's part of the data that the AI is working with. So there are real problems with how do these laws actually work and whether they can. So Maryland has a similar thing where employers cannot use facial recognition during hiring without informed written consent. But let's look at the dynamics there. You're applying for a job, it's a tight labor market, you really need the job to pay your bills, and the hiring person says, "Well, we use an AI program that will analyze your face and emotions during the interview, and we'd like you to give us express written consent to do that." Do you really say no? I don't know if the power dynamics and the economic pressure makes these laws protective or not. If the answer is let people know and get their consent, you're just pushing people into having to give consent, which maybe is not the right approach and doesn't really mitigate harm.
I wonder, so another rabbit hole that we haven't really talked about before, it's increasingly clear to me that identity verification is going to be part and parcel of doing anything on the internet. Because particularly in employment, there's all sorts of craziness going on in the application and application review process.
Right.
Lots of fake people applying for fake jobs. I saw an estimate the other day that 10% of LinkedIn profiles are fake.
What's that about? Why are people doing that?
Well, in some cases, the example most often used is North Korean agents trying to get jobs inside of American companies. And you could do that for surveillance reasons, intelligence gathering reasons. You can also do it for the money. Right.
Okay.
So you can't walk in anywhere in the United States and apply for a job as a North Korean. But if Sally Smith happens to get the job, and Sally Smith is just a beard for a guy somewhere in North Korea, that kind of stuff is happening. That kind of stuff is really, really happening, and it is unnerving.
Fake profiles, fake documentation, fake I-9, fake social,
fake everything.
Fake. Wow. Okay.
So the other day I downloaded OpenAI's latest video thing called Sora, S-O-R-A, Sora. And it took a picture of my face and one ear and then built a working animated, quote, avatar of me that looked just like me, spoke just like me, and said things that I would be likely to say. So it built the avatar, and then it went and researched the stuff that I've written and put words in my mouth from the stuff that I've written. And it was fairly believable on the first pass. And you could tweak it more and more. And it did things like, it took me from this look that you're seeing right here to sitting on the couch, and you could see all the way down to my knees sitting on the couch. And I didn't give it any of that, and it was a fairly accurate representation. It was pretty interesting. So that kind of fake is coming all over the place. It's coming all over the place. Identity verification, right? And identity verification means that once you have a standard for identity, you have your papers on the internet, you can attach all sorts of information to those papers that you might not be able to do otherwise, and it amps up the surveillance quality of the overall internet.
It also diminishes the reliability of all information on the internet.
Give me another couple of bullet points.
Well, if you can make up fake people with fake credentials and fake everything, that can potentially pass muster through the verification systems, and you can manipulate what those people do and say, And, suppose they get hired. There's just so much potential for shenanigans.
Well, so that's why I think broad scale identity verification is going to become a thing. Greenhouse, just before John Strauss retired, Greenhouse rolled out a partnership with Clear. Mm-hmm. And so it has access to 40 million biometric profiles in Clear to use as a way of validating that somebody is who they say they are. That kind of thing you'll see more and more and more of as it becomes harder and harder to distinguish fake from real.
Right, but what happens when someone buys Clear and applies this to all of that information and starts manipulating that? That's the thing. Without a single source of truth and everything commoditized, it becomes problematic.
Oh, that's very interesting. So what you're saying is, if you're sitting on the Clear data, there's nothing there to stop you from harnessing it for other purposes. That's very interesting.
Right. That was the problem with 23andMe and Ancestry when they both got sold, and basically everyone deleted all of their accounts and data because there was no trust in the market. And no requirements, very, very little regulatory protection. And in the US, that is consistent. We are the Wild West. And our default is everything's legal unless someone says it's not. And half the time they say it's not legal, but there's no enforcement, or the ability to enforce it is so cost prohibitive that it might as well be illegal. And the EU takes a completely different approach. They are very concerned with privacy and data security and what happens when people get a hold of identifying information and misuse it, because it allows for extreme abuse of power by people who have it.
Got it. So adjacent, I am a owner and operator of a medium-sized business, and there are all of these regulations coming out that probably apply to me because people come to my website and people apply to me for jobs. How in the world do I keep track of it?
Yeah, I don't think any small to medium-sized business can. They don't have the resources. It's not their priority. And so what we're seeing is the technology companies doing that lift and embedding compliance as part of the offering. We will track the data. We will make sure that you're up to speed. We will make sure that we know which laws apply to you and make sure that the processes happen, the reporting happens. And that's an actually great use of technology.
So you do that. You set up something. You say we're going to monitor it, and you miss something, and the client gets tagged with the thing that you missed. Software liability isn't to the point where that's the responsibility of the vendor. That there's this caveat emptor in the marketplace that says you buy whatever you want, but you're still accountable for the result.
That is true, but we're seeing that shift too. One of the things that California regulators have made clear in the new set of regulations is consistent with what the court determined in the Mobley versus Workday case, which is vendors are potentially liable for discrimination, for other workplace violations, if you can prove that they caused them. And that's a big if. That is a big, huge if. And it's going to be a case by case determination. But the general belief that vendors could be liable is new and big, and a real market incentive for those tech companies to protect themselves and their clients.
That's a very, very interesting insight. So tell me a little bit about what you're doing with your time these days.
Well, I'm thinking hard about the use of AI in organizations and what tools are out there and how employers can make policies and train employees for responsible use of AI. Because we're dealing with a situation where employers roll out their very carefully vetted, well-governed tools and use cases, and the employees are using ChatGPT on their phones. And often on their work laptops and desktops, and all sorts of things are getting uploaded into these apps where they become part of training data. They may or may not be findable if you wanted to try to extract that. We did an experiment with social security numbers not too long ago, and in most of the apps there were guardrails about being able to extract that information. But we have to train people how to consider prompts, how to understand the bigger context of what they're trying to look for or figure out or do, how to understand that the shortcut may be the long cut. If you get an answer that's slop and you have to go back and figure out what part of it is usable, what part of it's not, and edit the whole thing or rewrite it. So, that we're in this really, really interesting time where we have all these fascinating tools that can do magical things, but we don't know how useful they are yet. And we don't fully understand what happens as a result of using them.
Yeah, there's a lot to be concerned about there. There's a whole lot to be concerned about there, from the idea that these tools stop parts of your brain from functioning,
Right.
to the personal safety issues that you're sort of hinting at here, that disclosing a bunch of stuff to a great arbiter in the sky might just come back to bite you in ways you didn't expect.
Well, yeah. I mean, we saw that. What was the check-in app that everyone used early on to, let people know where they were going so that their friends could meet them or whatever? I can't remember. It's been too many apps ago, but but my initial reaction to that was, oh my God, somebody who wanted to harm you would be able to track you and do that. And your initial reaction was, oh man, if you could set that up for the executives of a company, you could learn all sorts of competitive intelligence about where they were going, who they were meeting, what's going on. And then some of that stuff started happening and people stopped using it or started checking in to get the points, but only after they were home. So, there was this whole gamification and we've abandoned more than we've developed along the way. And I don't think we've really sort of gone back and looked at what worked, what didn't, and what were the issues as we go forward. But it might be an interesting exercise.
So throughout this conversation, we've been talking about things that I would generally characterize as safety, right? Safety includes freedom from discrimination. It includes freedom from emotional harm. It includes freedom from financial manipulation. There's a lot of things that safety encompasses. And I think that's liable to be the replacement for the idea of responsible AI, is that we're going to need to start talking about safe.
Yeah.
And that raises an interesting question, and you'll have a good legal opinion on this. What is harm? How do you tell if something's harm?
Yeah, the law is really bad at that. It's really bad at that, because the law is almost always backwards looking. You don't create laws until you perceive a problem. And even though those laws are designed to mitigate or prevent harm, they mostly just punish people after it's too late. The same with litigation. That's all about redressing harm that's already happened. And so law is really, really crappy at preventing harm. And it's rarely designed to do that. There are safety regulations and environmental regulations, and now we're seeing regulators try to figure out how to do that with AI, but we don't know exactly what the harms are. We don't know exactly how they are caused. And all law can really do is hold people accountable for violating the law rather than actually prevent the harm. So what we're dealing with are, what are the incentives that you can create to encourage AI organizations or developers to create and roll out products that will not cause harm, and they're financial, but we've seen how companies analyze that. Remember the Pacer? The auto industry is replete with examples of, oh yeah, we knew that was a design defect and that people would get killed, but we decided that litigating those cases was cheaper than changing the design.
I think there's more and more of that kind of thinking to come.
I agree.
Right, and the same sort of dynamics that drove safety in the car industry will start to apply here. You don't know what the harm is, so when you discover what the harm is, the way that you're liable to discover what the harm is with a letter from a lawyer, right? And you get enough letters from lawyers that you start going, oh, that's expensive. And then you install safety mechanisms. But you don't put up safety rails on high rises until somebody falls off.
Right. But some organizations have more incentives to be proactive than others.
Oh.
Sure. Great big publicly held regulated companies have a lot more at risk, a lot more reputational liability, brand liability, everything liability. And so they're going to be more proactive about what they're doing and how they're doing it than a startup that is just trying to get to revenue. Because safety doesn't matter to them. They don't have anything to sustain and protect. They're building. And so, if you want innovation, if you want to try new stuff, there are great places to do that. And if you want something that will provide you with the most defensible use cases, there are organizations that are focused there.
So I think we just made a full circle, but let me test to see
Okay.
if we made a full circle. At the beginning, we started talking about frontier companies as defined by the new California AI regulations.
Yes.
And I think now that we've been all the way through this loop, I think it must be that frontier means you continue to get a pass as if you were a startup. Is that fair?
Well, kinda. And it's evaluated based on existing gross revenue and how much computing you're using, right? And the requirements are simply disclosure requirements.
Right, but you gain the only reason it would be in the law is if you gained some advantage from being a frontier company or some additional rights for being extended to you as a
No, no,
frontier
no,
company.
no. You're gonna see any company subject to these laws dividing itself so that it doesn't meet the criteria.
Oh, wow, that's really interesting. So this
Yeah,
is
no, I mean it's whack-a-mole. It's regulatory whack-a-mole. The minute you get a definition, you try to route around the definition so that it doesn't apply to you.
well, maybe in one of the future editions of the HR Examiner podcast, we could have 6 or 7 people competing in a game of industrial whack-a-mole. That would be fun.
Sure. How do you route around this requirement?
Yeah, yeah, awesome. Well, Heather, it's been a treat as usual. Thanks for a great conversation. Do you want to let anybody know how to get a hold of you or that sort of thing?
Well, you can find me on LinkedIn, and that's probably the easiest place. And I'm happy to connect there. And I um, post regularly, and I'm still figuring out what I want to say next.
Cool. Thanks, Heather. It was great
Thank
talking
you.
to you. Bye-bye.
Bye.